Another great suggestion from a viewer regarding a hot topic: unemployment and pandemic unemployment assistance. Well, how do you apply and what do you do if you're denied your benefits? And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flessas. Applying for unemployment benefits is usually done online. It's a pretty simple process. Every state has different procedures, so I can only make general statements here. When you go online to apply for the first time, you should read the resources that are available when you get to the applicable website. Take your time. You want to be able to understand the process and you don't want to miss anything. You'll find instructions on how to apply and eligibility standards. The big issue that I believe most people are interested in is, what if I'm denied benefits? If you're denied, due process provides that you can appeal the determination. The issues that you'll appeal are the reasons why your benefits were denied. You'll receive the decision in writing or online. Look at it carefully. Study the reasons for your denial carefully to prepare your application for appeal. But here's a very important point. There are always deadlines to make an appeal. There are, in many cases, separate deadlines for online appeals and written appeals. Make sure you know that. If your determination of denial is mailed to you, the documents that you receive will always include instructions on an appeal. The same instructions will be online. Now read the appeal instructions carefully. You'll need to read the important rules of the hearing and information regarding your appeal. Many appeals are conducted on the phone. The appeals are informal and usually attended by the hearing officer, you, and if applicable, any person objecting to your appeal, like your employer or a representative of your employer or the employer's attorney. You can bring your own witnesses too, but I'll get to that in a minute. Hearings are usually scheduled as soon as possible. The appeals are conducted like a mini court trial, but not as formal. There are things that you must do prior to the date of your appeal hearing. You usually must submit documentation that you want to use as exhibits and evidence in advance. If you want a person to attend but not sure if they'll appear voluntarily, you can subpoena the witness or witnesses. A subpoena may require you to submit that person's name, address, relationship, and the testimony that's related to your case in advance. If you want a subpoena to include documents, then you have to identify the documents, who's in possession of the documents, and how those documents relate to your case. Subpoenas usually must be granted by the agency to be issued, but check your rules. The hearings now are usually recorded. All testimony is taken under oath. The issues go to the reasons why you were denied benefits, so stick to that and don't deviate. The hearing examiner will start the hearing by explaining how the hearing is going to be conducted. Both sides then state their opening remarks. Then the appellant, that's you, calls their first witnesses, or the appellant is the only witness in most cases. Written statements that you attempt to use as testimony will probably be rejected as hearsay. The reason being is that the other party can't cross-examine the written statement. But if you're going to use medical documents to support your case, you must obtain those from your healthcare provider that's treating you. In most cases, you don't need the healthcare provider to be physically present to testify in your behalf. Each party has the right to cross-examine each other's witnesses. Sometimes the hearing examiner will ask questions of the parties to clarify the testimony. Upon the conclusion of the hearing, both parties are allowed to make their closing remarks to the hearing examiner and ask that their evidence be admitted to the tribunal record. Any objections to the admission of evidence by either party must be made at that time. Remember, every state has different rules, and you must know the rules before you appeal so you can prepare yourself for the hearing. The hearing examiner's decision is usually mailed to you within a specified time. That decision is called their final decision. But you'll be provided with information how to make another appeal of that decision to a higher authority. Usually the second appeal is done exclusively in writing, not a formal hearing like your first appeal. So you may have two kicks at the cat when appealing the denial of benefits. This same process may work for pandemic benefits. You should look online for the procedures and appellate rights. Well, I hope this helps. I'm attorney Robert Flessas. Thanks for watching, and I'll see you in the next video.